a very warm welcome to all of you joining us today on this important topic of Arbitration Bar of India. Before we start, this is Legal Darpan and this is your host Sushila Chaudhary. We meet every week to discuss legal current affairs of that particular week. Now, before we dive any deeper into it, let's just understand what does the term arbitration mean and where it comes from. The term arbitration is derived from Roman law, referring to a private arrangement for resolving disputes through a neutral third party called an arbitrator, instead of going to an established court. So this is an alternative dispute redressal mechanism. Other kinds of alternative dispute mechanism include mediation, conciliation. Now, parties in arbitration, parties agree to submit their present or future disputes to arbitration and abide by the arbitrator's decision. Now, recently, the inaugural ceremony of Arbitration Bar of India marked a pivotal moment in the country's legal landscape, attended by prominent figures such as External Affairs Minister Dr. S. J. Shankar, Minister of Railways and IT Shri Ashwini Vaishnav, Attorney General R. Venkata Ramani, Solicitor General of India Tushar Mehta, and the President of Arbitration Bar of India, Advocate Gaurav Banerjee. Now, Mr. Banerjee, in his inaugural speech, highlighted ABI's goals of promoting diversity, expanding the pool of young arbitrators, and influencing policy reforms. Solicitor General Mehta emphasized India's historical role in arbitration, while Attorney General Venkata Ramani called for elevating India's global arbitration status through inclusivity. Shri Vaishnav advocated for integrating technology in arbitration and envisioning a unified judicial interface. At the same time, Dr. S. J. Shankar, who was the chief guest of the ceremony, highlighted the role of high-quality arbitration in attracting foreign investments and fostering entrepreneurship. The Vice President of Arbitration Bar of India, Tejas Kararia, concluded by reaffirming ABI's commitment to excellence in promoting India as a preferred arbitration seat. Now, the event ended with a felicitation ceremony marking a significant step in reshaping India's arbitration landscape. Now, before we go any further, let's talk about the vision and the mission. So, the Arbitration Bar of India is founded on the vision of promoting excellence, integrity, and innovation in arbitration practice. It aims to foster gender and regional diversity within the field and expand the pool of competent arbitrators. ABI's mission is to establish a network for knowledge sharing, standard setting, and influencing policy reforms to enhance India's standing in international arbitration forums. ABI aims to nurture young talent and provide guidance to aspiring professionals in the field of arbitration. It will influence policy reforms to streamline arbitration processes and to make them more cost effective, ultimately enhancing India's global standing in the arbitration domain. Now, in India, arbitration particularly is dealt with Arbitration and Conciliation Act of 1996. At the same time, there is a provision in the Civil Procedure Code of India which talks about seeking arbitration, conciliation and mediation, or any of these alternative dispute redressal mechanism in cases where it is possible, so that the burden of the courts are lightened. Now, like we already know that our courts have been overburdened for ages now. There have been pendency of cases for a very, very long time. So arbitration is seen as an alternative dispute redressal where the person does not have to go to the court particularly, but under the Arbitration and Conciliation Act, they are provided with certain rules and regulations that we are going to talk about right now. So the Arbitration and Conciliation Act of 1996 is the key legislation governing the process of arbitration in India. The Act came into force on 25th January 1996, superseding the earlier Arbitration Act of 1940. Now, the current Arbitration and Conciliation Act of 1996 has a broader scope covering domestic arbitration, international commercial arbitration, enforcement of foreign arbitral awards, and introducing the concept of conciliation as an alternative dispute resolution mechanism. Now, the 1996 Act was heavily influenced by the unilateral model law on international commercial arbitration adopted by the UN in 1985. The UN General Assembly recommended that countries consider this model law to bring uniformity to law and practice international arbitration. Now, India, being a member state of the UN General Assembly, tried the same, and India's Arbitration and Conciliation Act of 1996 is modeled closely on the unilateral provisions. Now, let's talk about different types of arbitration this Act recognizes. Firstly, there is domestic arbitration, which is conducted entirely in India. Then comes the foreign arbitration, which is held outside India, but it requires enforcement here. So, the foreign arbitral award that we have talked about are a part of this, that they are held outside India, but for enforcement they are required to be here. Now, the next kind of arbitration provided in this particular act is ad hoc arbitration. Now, ad hoc arbitration, in this, the arbitration is governed by the party themselves. In general, if we see, there is an arbiter appointed, and the arbiter is generally a person who has held a high judicial post, such as a retired high court judge or a retired chief justice of high court, or a retired judge of Supreme Court. So here in ad hoc arbitration, the arbitration is governed by the parties themselves. Then institutional arbitration is conducted under the law of an arbitral institutions. Likewise, there are a lot of different institutions that provide arbitration. So institutional arbitration would be such. Now, there is the normal domestic in domestic arbitration, there is not particularly requirement of an institution to facilitate arbitration. There can be one individual arbitrator, and around whom the whole arbitration can be revolving. Now, statutory arbitration is the arbitration that is mandated by law. When in CPC, the provisions that are provided in CPC, they gave arbitration as an option to other people, but now under the Arbitration and Conciliation Act of 1996, in certain aspects, there is arbitration which is mandated by law. Now, for example, not in arbitration, but if we talk an example in mediation, in cases where there is, currently this is the trend, that in cases where there is a divorce proceeding going on, the first step generally which is preferred by the court itself, even if you approach the court, they are going to refer you to the mediation center. So here we can say that that mediation was mandated by law. So in such a situation, there is also statutory arbitration that is provided for in types, and that is mandated by law again. Then international commercial arbitration, in this there involves a foreign party. So you see, there is a difference between foreign arbitration and international commercial arbitration. In foreign arbitration, the parties can be from India, but the only part there is that the arbitration took place outside India, but it would require enforcement here. Whereas in international commercial arbitration, it involves a foreign party, so there is a possibility that the type of arbitration that is being conducted is conducted in India, enforced in India, but the party is a foreign party. Now, after knowing these types of arbitration, let's look at the process of arbitration. So the process of arbitration typically involves the following steps. Firstly, the aggrieved party sends a notice initiating arbitration to the defaulting party. Then the parties choose a qualified arbitrator, either as per the arbitration agreement or through court referral. So what is meant by here the arbitration agreement or through court referrals? So arbitration agreement is majority of the times a clause in a contract that two parties get into, where they state that in case of any dispute arising out of this contract, the parties shall go to arbitration before they approach the court. So that would be an arbitration, and that such clause constitutes the arbitration agreement. Now the court referral arbitration, what do you mean by court referral? In certain circumstances where there is an absence of arbitration agreement, the parties may approach the court directly and the court may refer arbitration to them before entertaining their plea, as it is an alternative dispute redressal and it is very helpful in reducing the burden of the court. So secondly, so first, like we talked, that first there will be a notice of initiating arbitration. Secondly, there will be a qualified arbitrator chosen. Third, the claimant files a statement of claim outlining the issues to be resolved. Now the claimant and the aggrieved party are the same people. So the claimant files a statement of claim outlining that the issue, what issues should be resolved. This is very similar to how we file a case in the court, where the party who is taking the matter to the court firstly lists all the claim that they have. Now second, after the claimant has filed the statement outlining all the issues that they need to be resolved, the respondent files a statement of counter claim in response. So like there is a plaint in CPC, in commercial case, in civil cases there is a concept of plaint. There is a concept of written agreement also. Similarly, here also in the step 4 we can see that the counter claim is similar to the written agreement, written statement under the civil law. So the respondent files a statement of counter claim in response and the arbitration proceedings commence. They are conducted confidentially and flexibly. The main reason arbitration is preferred in today's time over court proceedings is because the flexibility that is involved here. In court there is a certain steps, procedures that are to be followed which elongate the length of the proceedings, but here in arbitration there is that flexibility that there are no very strict rules that are to be followed. So there is confidentiality, flexibility, and it is comparatively quicker also. So lastly, in this case the arbitrator renders a binding arbitral award which is similar to a court judgment. So like a judgment, the main the main document which contains the resolution of all the rights and duties, which contains the reasoning for such a judgment, would be considered an arbitral award. Now arbitral award is similar to a court judgment. A court judgment is given by a judge, whereas an arbitral award is governed by an arbitrator. Now such an arbitral award, if in case one of the parties is not satisfied with this arbitral award, there is a place where they can, in a court of law, they can appeal to the arbitral award. So if we see that like we have studied in contract law, that an absolute restraint to legal proceedings would make a void contract. Now here in this scenario, we are not absolutely restraining legal proceedings. I know this might be a doubt, but we are not absolutely restricting legal proceedings. We are just adding another step. If we are not satisfied with the step, there is still an option for the party who is still aggrieved to approach the court. So, like all in all, in conclusion, that I would like to say that arbitration again is a very great alternative dispute redressal mechanism which has helped in reducing the burden of our courts, and the inauguration of Arbitration Bar of India heralds a new era of professionalism and inclusivity in India's arbitration ecosystem. The ABI is committed to shaping the future of arbitration through excellence, diversity and policy advocacy, positioning India as a global leader in dispute resolution. Now thank you so much for watching this video. If you like the video, please like. If you have any questions or comments regarding the topic or the video, please put them in the comment box and share this video with the like-minded people so that they will be benefited from it. And subscribe to Pratham Test Prep channel for more such informational content and help with your entrance exams. Thank you so much.